Well, good morning, everybody. I'm told that there's been a lot of rain in Latvia in the last few days, but I have to say that my arrival has banished it because the weather has been so lovely all the way through that this has been every bit as enjoyable as last year's conference. And I'd just like to thank the Patent Office for organising it in partnership with its international partners and for doing me the very great favour of inviting me to be part of it again. So I'm going to talk for about 40 minutes about a slightly disparate collection of issues relating to cross-border crime and IP crime generally, but principally in its cross-border aspect. First of all, I want to talk about territoriality, which is an important concept in intellectual property, which has certain consequences for jurisdiction. Then I want to talk about a specific decision of the European Court on burden of proof. Then I want to make some remarks about the seizure of domain names, and I won't be coming to any conclusions about that. And finally, if I have time, I'll talk about a project that we have at WIPO, which is about attempting to prevent crime by attacking the financial model of piracy. So I thought I'd begin by an illustration of why we need to be concerned in the criminal sphere with the international aspects of intellectual property. At one time, a few years ago, a website called Kick-Ass Torrents was one of the most popular websites on the internet. It was the most popular pirate site using the technology BitTorrent, which I'll be talking about later today, but essentially it's a way of sharing files very efficiently, and typically the vast majority of those files were pirated. Now this website was as I say, a torrent site. I don't need to go into the technology, but essentially it's a long list of what look like links which allow you to identify pirate files on the internet and then acquire them in a very subtle way. Now, the site was launched in 2008 by a Ukrainian man called Artem Vorlin, and he set it up through a company in Ukraine called Kryptoniet, or Kryptonite, I'm not quite sure how you say that. After its success began to grow, the right holders and the authorities realized that it was of a serious criminal enterprise, and they chased after it. And Mr. Vorlin did not give up at that point. He simply moved his website to different domain names administered on behalf of different countries. And this is only a partial list of the different places that the site was nominally based in. The Philippines, the island of Tonga, Trinidad, Somalia, of all places. It was chased out of Somalia quite quickly, surprisingly enough. The Isle of Man, which is near England, Costa Rica, and so forth. Now, of course, where the domain name is registered is only one aspect, one geographical attachment. The persons behind the website may be in many different countries. And what is more, the infrastructure, the servers, the programs that make the site work may also be in yet further countries. In this case, the infrastructure, the equipment, was situated in the United States and in Canada. And you'll note that none of those, apart from the first one, the .com domain, none of the others were American domains. And the money, of which no doubt there was a lot, was flowing into accounts in Estonia and Latvia. So Latvia has a part to play in this story. Now, the site began to be blocked in various countries, including the United Kingdom, in various different ways, on various different legal bases. But in 2016, the American law enforcement authorities filed a criminal complaint in Chicago alleging various offences of copyright infringement and seeking the seizure of the domain names that were currently in use and the proceeds of the activities. Another fascinating detail is that the money that was held in Latvia was held on behalf of a company that was registered in Belize. So the geographical spread from a legal perspective was enormous, even though probably Mr. Vordin was still sitting at home in Ukraine masterminding the whole thing. Now, he made the mistake of going on holiday, I think it was, changing planes in Poland. And in Warsaw Airport, they were somehow waiting for him, and they pounced on him and arrested him. And he's been in Poland ever since, fighting an extradition attempt by the American authorities. And that included litigation in the US to try and release himself, and that was unsuccessful. So you see that this one site, albeit a very big and important site, involved many different countries, and the legal complexities are obviously severe. But the one thing that we can hang on to in the field of intellectual property is that under the international framework of treaties to which our countries are largely members, the principle of national treatment is applicable. So this fundamental principle was established in the Paris and Berne Conventions, and it runs through all the major copyright treaties that have followed Berne. And national treatment essentially is that we will treat authors of foreign countries in the same way as we treat the authors of our own country, and we don't discriminate between them. And virtually all countries, one or two small exceptions, are members of Berne, so the issue of where the rights come from is not really a pressing one. Now, in relation to crime, the only international treaty which sets out requirements for criminal enforcement is the treaty called the Agreement on Trade-Related Aspects of Intellectual Property Rights. This is part of the set of agreements that created the World Trade Organization in the mid-90s. And Article 61 of the TRIPS Agreement, as it's called, requires that members of the agreement will provide for criminal procedures and penalties to be applied at least in cases of willful trademark counterfeiting or copyright piracy on a commercial scale. And it goes on to say that the remedies must include imprisonment or fines sufficient to provide a deterrent consistently with the level of penalties applied for crimes of a corresponding gravity. And also it provides, and this will be relevant later in this talk, that in appropriate cases, remedies available shall also include the seizure, forfeiture and destruction of the infringing goods and of any materials and implements the predominant use of which has been in the commission of the offence. So that's the international obligation. Now, in Latvia, you have on the face of it, very simple criminal offences. On the one hand, is there an infringement of copyright or related rights? And secondly, is a certain threshold of seriousness achieved? In particular, does it cause particular substantial damage to the right holder? And similarly with trademarks, one, has there been infringement of the trademark? And secondly, has there been substantial damage or a commercial scale activity? So in deciding criminal cases, we can't escape addressing whether there's been a civil infringement, because that's an element of the criminal charge. We prove that, and that's the more complicated bit. Now, although we have national treatment, and that's the cornerstone of the international protection of intellectual property, it remains that intellectual property is territorial. It's territorial either at the national level or in the European Union at the regional level, where there are certain regional rights. But nonetheless, there is a border that surrounds each trademark or each copyright. And this is illustrated very nicely by an American case about the Beatles film Yellow Submarine. Now, Yellow Submarine was made in the 60s before the home entertainment revolution came along and we all had DVDs and video cassettes. The people who produced the film, Super Films, gave a license to United Artists, which was a very successful distributor in those days, to distribute the film in cinemas and on the television. So that happened, all fine. Years passed, then video cassettes became very popular, created a whole new business for the film industry. the rights that have been granted to United artists had found their way to the defendant, MGM Pathé. And MGM Pathé started entering into distribution agreements with people abroad, in particular in Russia, I think this case was, for the distribution of video cassettes. And the producers, Superfilm, sued them saying, we didn't authorize you to do this, you're infringing our copyright. And the court said, well, that is true, but, well, that may be true, but note that the license, your position was only in relation to the licensing of cinema distribution and television distribution. But that having been said, you are trying to stop activities which are taking place outside the United States. And your rights, the rights you licensed, are American rights. So we in the US can do nothing for you because you're not alleging an infringement of the rights you assert in the United States. So you have to assert Russian rights, and you might have to go to Russia to enforce those rights. That's a separate question. Now, when we're talking about enforcement on the internet, especially in particular in relation to copyright, we're very often concerned with the so-called right of communication to the public. This this emerged in 1996 in the WIPO Copyright Treaty, but we find it pretty much verbatim in the 2001 Directive on Copyright in the Information Society, which of course is our controlling law in the European Union. And the right of communication to the public is the right to authorize the communication of works by wire or wireless means, so by any means, including making available that work to the public, so that members of the public may access these works from a place and at a time individually chosen by them. Now, that form of words was designed to go beyond the existing technological infrastructure for making works available through broadcasting to cover the case of internet distribution, because it was perceived that it might be difficult to show that people were actually receiving programs or works on the internet, so they made it an infringement to make the works available for access, so that it would be something that the author could forbid for someone to simply put a work on the internet so that the public could access it. You didn't have to show that they were accessing it. Making it available for access was in itself an infringement. But of course, broadcasting or streaming equally would be an infringement of that right. But the question arises, given, if you look back at the case of Mr. Vorlin, Kick-Ass Torrents, I'm the judge in Latvia. The prosecution say there's been an offence of piracy. I ask myself, well, where did this offence take place? Yes, the defendant is in front of me, but where is the offence? Did it take place within my jurisdiction? And this issue was first clarified in a case that isn't actually about copyright, it's about database right, but everybody takes it that it determines the question both also for copyright, which is called Football Dataco and Sport Radar. And in that case, it concerned betting information that was to do with football games. And the plaintiffs had a very valuable database of information about how games had been played, who had scored, how many penalties there were, and so forth, which was of great interest to people who liked betting on football. And that was a company in the United Kingdom. Now, a German company made a copy of that data and made it available from Germany to people in the United Kingdom who were customers of UK and Gibraltar betting companies. So Football Dataco sued Sport Radar, the German company, in the United Kingdom, saying, you have infringed our rights in the United Kingdom. Now, it's important to separate two issues here. First of all, the issue of substantively, what is the infringement and where does it take place? And secondly, the jurisdiction of the court. Those are two separate issues, and I'm not talking about the second one. But the cases that have concerned jurisdiction have been very informative as to the substantive nature of copyright under the directives. So in this case, the German company said, well, we may or may not have copied your data, but we're a German company. The data is in Germany. So nothing has happened in the UK. Possibly we're infringing your German copyright, but you haven't alleged that. You're saying that we've infringed your UK copyright, and with the United Kingdom, we have nothing to do. And the European Court said that where data is sent from one country to another, then there's an act of communication to the public, at least in the country to which the data is targeted. And in this case, it concerned English football. They were dealing with English companies. They were charging in English money, and so it was obvious that their objective was to make that data available in the UK. And so there was an infringement, or if there was an infringement, it was taking place in the UK. So that, to some extent, sorted that out. But in the analog world as well, we may get similar questions, where again we have to think about whether there is an infringement in a country that's connected with, but not actually physically where activities have taken place. Now, I think this case was mentioned yesterday. It's a very interesting case about furniture. And in this case, at this time, in Italy, certain famous furniture designs were not protected by copyright. I think the situation has probably changed now. But in those days, you could make copies of famous Bauhaus chairs and so forth in Italy, and that was fine. You weren't infringing anyone's rights. However, in Germany, and I think in most of Europe, they were protected. And so this Italian company had a great business idea. They offered to sell this lovely furniture for much less than the licensed copies, and said, buy it in Italy, and we'll deliver it to you in Italy, and by the way, we can help you find someone to deliver it to you in Germany. So in that way, they said, our hands are clean, we're not doing anything in Germany. But they advertised in Germany, and their website was pointed, as it were, to Germany, since it was in German. And the owners of the rights sued them for an injunction in Germany. And the question arose, well, if the plaintiffs cannot show that there have been any sales by the defendant in Germany, is there still an infringement in Germany? And the answer was yes, because advertising the product is part of distribution. So the definition of the substantive act of infringement includes advertising. And so in this case, as similarly in the Sport Radar case, the fact of targeting meant that although everything the defendant had done had taken place in Italy, he had in fact committed an offence in Germany. And I mentioned this case, Donna, which predated Dimensione, because it's very important from a criminal perspective, it seems to me. Mr. Donna was the man with the lorry. He was the chap who went to the factory in Italy, picked up the furniture, and took it to the customer in Germany. And he was an independent contractor. He was not employed by the Italians. And the argument was, well, he's working for the customer. He's not working for the furniture company. Now, Donna was prosecuted in Germany for aiding and abetting the criminal infringement by the furniture company. So this illustrates a very important aspect of anti-piracy, which is that very often people who are involved in the enterprise can be made criminally liable as accessories to the substantive offence that's taking place at the instance of another person. So it was a bit hard on Mr. Donner that before the furniture company was sued, he was prosecuted, but nonetheless he was guilty because he was helping the Italians commit the offence I've described in Germany. So, as it were, the offence jumped over the border. Now, this question of territoriality also relates to trademarks, which of course a trademark is granted for a territory. It's not a and of course the same trademark may be owned by different people in different countries. So when we're thinking about where the infringement takes place for criminal purposes, we first of all have to decide what use is. A trademark essentially allows the owner to control the use in trade of the mark for the goods in respect of which it is registered or similar goods. So what is use? We find in the trademark regulation and the trademark directive of the European Union some details as to what falls within this category of conduct that the owner of the right is allowed to restrain. And it includes offering the goods, as you see in subparagraph B, and it also, in sub E, says using the sign on business papers and in advertising. And since internet commerce is very much a form of advertising, we are very interested in any use of intellectual property which is involved in advertising. Now, there's been a line of cases which has decided that, very similarly to the Sport Radar case, that where a trademark is directed, where advertising is directed at a particular territory, then there is a use of the mark in that territory. And since we don't know necessarily where a particular website selling fake handbags is located, it's very helpful that what the courts tell us we're interested in is what is the target. And so you might have someone in Latvia who thinks it's a good business to set up a website in the Far East and sell fake handbags to customers in Latvia. Well, the offence is clearly taking place in Latvia because his site selling to people in Latvia, targeting people in Latvia, is an infringement in Latvia, irrespective of its location in the real world. So I'm not going to go into the details of these cases because time flies, but I would like to mention this case which was mentioned yesterday of AMS Neve against Heritage Audio, which just came out this month. And as was mentioned, this was a case where someone was in Spain was selling copies of British manufacturers' hi-fi equipment, and the owner of the mark sued in the UK. The defendant said, well, there's no act of infringement taking place in the UK because I haven't sold anything in the UK. And the same answer came back. You are selling to UK customers. The plaintiff doesn't have to show that you actually made any sales if you are targeting that jurisdiction. So I think that we see a very clear theme emerging across both copyright and trademarks, that targeting is the essential thing when it comes to localizing an infringement that is taking place substantially as a result of activity outside the country. However, that having been said, of course, there's always a complication. Where there actually is a sale, then we don't have to worry about targeting. So there's clearly been a use in the country if there has actually been a transaction. Mr. Blomqvist was a Danish fellow who bought a fake watch from a website. And it must have been a very expensive watch at the end of the day because the customs in Denmark seized it when it came in, saying this is a fake. And Mr. Blomqvist wouldn't accept it. And his case ended up in the Court of Justice in Luxembourg. And he said, look, there's been no infringement in Denmark. Maybe in China, but it's my watch. I want it. My fake Rolex. And in fact, the court said, well, doesn't matter about targeting or anything else. You bought a watch. It came to Denmark. It's a fake. That's a use. That's a counterfeiting of the mark. End of story. So in those cases, it's much simpler. Now, I'd like to move on to a very interesting case that came out last year relating to the proof of infringement in copyright cases. Now, typically, you'll have a right holder who's investigating pirating on the internet. They detect that a particular internet account is being used for pirating. They get information from the internet service provider. Whose account is this? They say it's Mr. Smith at this address. And then they send a letter to Mr. Smith saying, you've been pirating our film or our software, and you must stop, or you must pay us damages, or both. And in that case, Mr. Smith writes back saying, well, I don't know anything about this. It could have been my son. It could have been my mother. I don't know. Thank you for writing. This is the end of the conversation. What is the right holder supposed to do? In this case, it was a case in Germany. Someone had used Mr. Strotzer's internet account to pirate a copy of an audio book. And that is in itself is interesting, that actually literature is being widely pirated now, and audiobooks on the internet. It's not just music and films. So Mr. Strotzer said, well, yes, of course, it is my internet connection, but my parents are in the house as well. You work it out. And in Germany, that was sufficient to say, well, we don't know. The plaintiff has the burden of proof, and he hasn't proved that this defendant, Mr. Strotzer, actually pirated his works. Now, this went up to the Court of Justice on the question, was it effective, in quotes, effective to have a rule that allowed that kind of argument to succeed? Because in the Enforcement Directive and in the Copyright and Information Society Directive, it says that countries must have effective remedies. It's not enough just to pass a law. You must be able to make it work. And in this case, I think remarkably, the court said, well, no, it's not enough. The defendant must be at least required to give more details. He must explain what happened, why he says his parents might have been the pirates. Because in Germany, the thought was, in principle, the owner of the account is presumed to be the user. But if he can say there are other people with access to it, then that raises a sufficient doubt as to leave the plaintiff in a difficult position. And the courts would not go further because of respect for private and family life as a fundamental right. So as ever in these copyright cases, we're balancing different values. In this case, the court said it's not enough. You cannot deny the protection of copyright to right holders simply on the argument that it might in some way infringe family relations or family privacy, to require the defendant to give a proper explanation. Now, at first glance, that's a really remarkable decision, because it's not really an interpretation of the law. It's really the court saying you fail to, if you keep doing what you're doing, then you haven't implemented the directive, which is really the Commission's prerogative, it seems to me. But when you look more closely, the court, it was a hypothetical answer. The court said, if there's no other way to get this information, if there's no other way for the plaintiff to prove his case, then it would not be effective. And so in common law countries, where we have much stronger tools to get at information from defendants, probably the problem would not arise in the same way. But that's an interesting decision. Here in your civil jurisdiction, that's a case which I think you might well want to take into account when you're thinking about these piracy cases. So finally, I'm going to talk about domain seizure. Now, Sir Richard Arnold will be talking about site blocking, which is where instructions are given to service providers to block access to a site. But another way of making it difficult for people to get access to websites is to interfere with the domain name system. Now, you know that every website has one or more addresses, IP addresses, which is like a phone number, 1234.5789. Blah, blah, blah. those are difficult to remember. So we have this system of domain names, with www.wipo.int, for example. These are easy to remember. And there's a whole system, the domain name system, which means, and forgive me, you probably know all this, you type in your domain name and the system looks up what IP address correlates to that domain name and translates, as it were, the domain name into a number, and that's the IP address of the website. So if you could stop people getting access to the website simply by blocking that process, so I type in www.thepiratebay.org and it no longer takes me to the number, then even if I could write in the IP address in my browser and get to the site that way, it would still be very difficult for me to, or for the ordinary person, to get access to it. Now, in the TRIPS agreement, it says, and I mentioned this earlier, that the courts are required not only to have punishments available, but also remedies for the seizure of materials and implements, the predominant use of which has been in the commission of the offence. So you might have a textile, a label printing device in a pirate clothes factory where they're printing polo labels or Burberry labels. That machine's seized by the court and destroyed or sold because it's a tool that's being used for infringement. Well, a domain name arguably is such a tool, is such an implement that in theory should be liable to be seized. Now we find ourselves in this very interesting situation in which indeed in many countries domain names are seized, but in completely different ways. In the United States, for example, this is if you tried to go to kickasstorrents.com after the FBI got active, you would have seen this notice which informs you that the domain has been seized. In the US, the way they do this is under powers which allow the prosecutor to apply to seize property which has been used or is intended to be used to commit or facilitate specific copyright offences. So that's an application that the prosecutor makes, the US Attorney General, and the court issues a warrant, and effectively the warrant requires the domain name registries in the United States and in theory elsewhere to lock the domain and point it to the FBI notice. That's how they do it. But in one of the very first of the cases of this sort, which strictly speaking was a site blocking case, but it comes to the same thing, was in Italy in relation to the Pirate Bay. The right holders tried to get the court to block the Pirate Bay, at that time, the most famous piracy website in the world. And the way they did it, and they did it successfully, this is the notice that was put up when you tried to access the site from Italy. The way they did it was by saying, well, the website is a tool or thing which could aggravate the piracy offence. It could extend it. And as a result, it can be the subject of a preventive seizure under the Italian Penal Code. Now, when this, I was actually working for the film industry when this decision came out, and I thought, well, wait a moment, the website isn't in Italy. You can't seize it. Much as I like the order, that doesn't work. But it went all the way up to the highest courts in Italy, and they said, yes, you can seize a website in Italy even if it's not in Italy. And what that means is that effectively they tell the internet service providers, block access to this website. But that's on the basis of a criminal general power to seize property associated with criminality. So that's how they do it. Now, I could go on. This is the Danish version. This is a case which was litigated in the UK as well, Popcorn Time. And the Danes, they provide that an article can be seized as evidence. And again, this is a very curious thing. Conceptually, does it work? I don't know. This is an area where there would need to be some unification, perhaps. So the question that I leave you with is Latvia. What about Latvia? It seems to me that Article... and I know I'm treading on dangerous ground here by trying to talk about Latvian law to Latvian judges, but Article 361 of the Criminal Procedure Code provides for the attachment of property in criminal proceedings. It seems to me that that might well be the equivalent of the laws which are used in the US or in Italy for the seizure of domain names. And perhaps inspired by Italy, it might even extend to site blocking. But it'll be up to a brave prosecutor to take that case before you, no doubt. But with that thought, I thank you for your attention. Thank you.